Yeah. Oh my God. Here I am, 7 minutes later.
It's all right. You already had an account.
I didn't let me in. I don't know.
It's all right.
Anyway, here I am.
All right, great. Okay, give me 1 second to get the stream going. All right, cool. We have everything good. All right, Mark, please introduce yourself.
All right. Well, who is on already? Who do we have? Does it matter? But, all right. So I am Mark Goldstein. I'm an IP attorney. The IP is intellectual property. That's patents, copyrights, and trademarks. Do that for companies in the U.S. and companies internationally. So my background is computer science. So a lot of what I do is software and technology related, but a lot of other things I do are just plain old consumer products of any kind. And we protect the brand names, slogans, trademarks for any sort of product. You see behind me, let's see, that's a skateboard. It's that brand of skateboard. There's other miscellaneous things behind me that I've worked on in the past. You can see on the shelf as well. So, yeah.
It's fantastic. Yeah. Okay. So Cassio, David, glad you two are here. If you'd like to come up on stage to use your camera, optional. Your mic, necessary. Just raise your hand or use the text chat to let me know to bring you up. You can also post questions using the chat if you don't want to come up on stage. Totally up to you. But yeah, it'd be wonderful to hear what you're working on. If you don't have any specific questions, if you just simply share what you're working on and where your challenges are. I'm sure Mark has incredible insights to share, wonderful background, lots of different projects and fun stuff as he mentioned. So yeah, now's your opportunity. If not, I'm just gonna I'm gonna ask you questions, Mark.
Thanks, Gary. And for those people who are, I didn't look at the 4 people that are on. If you have questions, it's okay to talk about things in a general way. Don't go into the specifics. So let's say your thing has 10 features. Talk about the 5 that are more commonly known in public, and you can say maybe what the thing does. That way, you're not giving away your secrets to the world. And timing matters a lot in the patent world. So that's why I'm saying that. So answering the question Gary didn't ask, which is why does timing matter? Is you have a year within which to file a U.S. patent after something is publicly disclosed or publicly offered for sale. In that same vein, if you want to protect internationally, you must file something at a patent office somewhere before you publicly disclose. So the timing really matters. Otherwise, you can give away your rights. So even though you may be a US-based company, if you think you're going to have a large portion of your business in Asia, let's say Japan, Korea, or China, or Mexico or Canada, then you should get your stuff filed before you publicly disclose or offer for sale.
Look at that. You're already teaching people before I even ask any questions. I love it.
I don't want people to be afraid to talk about their thing or their general thing, whatever it happens to be, whatever product happens to be. So
I love it. I have actually a business question for you. This comes up a lot in the community, not just ours, but pretty much every online community of entrepreneurs. You have a lot of grifters that are pushing courses and content out there across social media and everything that exists, telling people how to make money fast. And one of these ways is to start an agency. A law firm, in a lot of ways, is an agency, right? You've got a lot of different people working with you. You're providing services to people. I'm curious, as a business operator, what sort of insights and kind of challenges, heads up, kind of concerns would you share to an entrepreneur that wants to start an agency, especially one that may be still in school or just getting out of school without much experience?
Oof. Yeah, it gets kind of tricky. So the most important things are make sure any content that you are using is something that you create on the one hand, or on the other hand, that you have rights to. Do not assume that some sort of content that someone said, hey, it's in the public domain, or hey, this is free software, or whatever it happens to be, that's probably not the case. There's probably some sort of rights to it, and even if it is free, you have to abide by certain rules and guidelines. So educate yourself about what the content is, what the materials are that you are going to be promoting, offering, or selling, or using to help yourself promote, offer, or sell your services, your products. That could be something as simple as just because something's in Wikipedia and it says that it's an image that is in the public domain or is wiki comments or who knows whatever it is, someone could label it that. It doesn't mean they labeled it the right way. So if you're going to use images, whether it's for a splash screen, a wallpaper, some sort of decorative item in your app or on your web page, don't assume that what images you pull down are available to use or they're already licensed. License them yourself. It doesn't cost much to go to stock photo websites, whether whichever brand you like, it's iStock Photo or Getty Images, whatever it happens to be. So get licensed IP, and then you can use it with confidence and keep your licenses in case somebody ever asks. So what happens all the time, it's a bit of a tangent, is that there are bots out there that are created by and run by different legal entities that represent people who do creative works, and they track down both music and images that are used on websites and web pages throughout the world. And then sooner or later, you're going to get a nasty gram, a lawyer letter saying, hey, you can't use this. And if you keep using it, you're going to be subject to massive damages because we see that you're getting, whether it's 1,000 eyeballs or 1,000 views or 10,000, whatever, multiply that out by whatever the damages would be, $250, $2,500 per view, per person, per whatever. It's an argument to be made. You don't want to, when you're starting out, after going live, to get one of those letters. It's going to really mess up your flow and distract you from what you should be doing. Same with any sort of content, whether it's a checklist, whether it's a video, whatever it is. Just because it's out there doesn't mean it is available for you to use freely without getting rights from the person who created it or from some entity that is been given the obligation or the opportunity to license it to others. So I don't know if these are the issues that you were getting at, Gary. Are they?
I mean, it's definitely a part of it for sure. I mean, these are definitely uh, a lot of the little things that founders, early stage entrepreneurs, sometimes even later stage ones overlook. Um, the idea of moving fast and breaking things is something that gets misrepresented a lot in these communities with entrepreneurs. But the other kind of like heart of what I'm curious about is if someone were to start an agency, right? Like what best practices would you suggest in making sure that they're not skipping other critical steps and kind of presenting themselves in a manner that they're not quite ready to handle, right? Because they don't have that experience yet. They haven't worked in the industry, the market. They don't have a large network of people to work with them, right? As part of an agency. A lot of times they're just going to Fiverr or something like that to grab someone to do some little task and, presenting it like they have an agency. Is there any like kind of like, again, like concerns or risk involved in that? And also, again, what are some best practices to help do this the
I
most
need
like
you to help
effective
me
way?
to. This is one of those things that happens all the time in my business is that I talk to a client or an entrepreneur and they talk to me about something that they are dug into and they know exactly what it is they're talking about, whether it's an optical lens or a rocket jet propulsion system or a way of streaming media better or faster. They use terms of art. So you're talking about an agency. Give me an example about what you mean by agency and what the issues are that you're seeing more specifically.
The most common ones that I see on, online are like digital marketing agencies. And that like, can be all sorts of different types of things, but typically like they're presenting themselves as an agency that's ready to do digital marketing for a company, whether that's like social media or ad buys or something like that, and really kind of like, like provide these services to a client. But the person that is starting the agency, is operating the agency, again, is in many cases, a younger person still in school, maybe just graduated, they might not even have a degree in marketing or anything related to digital marketing. They just, took a course that they got from a grifter that told them, hey, do these things and you can start your own digital marketing agency. Like that kind
Hmm.
of like idea of things. But there's other ones too that kind of,
Is the,
yeah.
okay, in that example you just gave, is that person who's opening the agency doing the actual work, or are they farming the work out to other people, whether it's friends down the block or friends in Chile or in India?
Yeah, typically they're utilizing the playbook from the grifters, which involves farming it out to the cheapest labor they can possibly find through other sources. Again, typically like Fiverr or something like that. And they themselves don't have much experience at all with anything related to what the agency's services are. So yeah, it's more of the farming.
Yeah, and what you're really getting at is the basis for any contract, which is the meeting of the minds. If I am hiring you to mow my lawn or paint my house, I expect that you can do what you say you're going to do, and then I will pay you after you do that, after the job is completed, or I may pay you a certain portion up front and a certain portion on the backside. So, if you're talking about how to protect the person who is the service provider, whether it's the painter or the lawnmower or the guy providing internet marketing services, it's be able to do what you're promising. Because there is a contract that will be formed, probably, I would hope, between you and your client or customer. So you're going to do something that's measurable. There has to be some sort of um, item in some sort of list about things that you're going to do. You're going to do these 1, 2, 3, or 4 things. You're going to increase sales. You're going to increase traffic, whatever it is. You're going to have a number of impressions that are calculated, counted somewhere online. And it's going to go up a certain percentage or a certain amount. And as long as there's an understanding between the client and customer and the agency, then that's great. You enter that contract, and then you have to make that happen. And then there has to be a certain pretty much standard for any contract. What's the amount and how are you being paid? When are you being paid? How are you being paid? What system are you using for payment? Make sure that's all specified. And the timing of things. If you're not paid, what can you do? What's the recourse? Or if you're not, if it turns out you don't provide the services, is it automatically discounted? And then instead of getting $1,000, you get 750 because you only had a 10% increase in ad click through or something versus a 22% ad click through rate that you had promised, something like that. So whether it's a breaching of the contract, which wouldn't be the situation, but a performance on a lesser level, if that stuff's built in. And if you are promising to do something, make sure you can do it. Otherwise, you could be subject to some sort of liability. And that could be as simple as giving them the money back, or it could be some sort of damages. Probably not damages, but we're talking, depends on the scope and scale we're talking about. As I understand your question, it sounds like more someone who's starting out, they're not going to have huge tens of thousands of dollars at stake in a contract, but maybe that isn't the case. Maybe that is the case. I mean, and that's not the situation. So if that's the situation, you're going to be far. If you're going to do the work, great. If you have a team of people, great. If you're going to farm it out, great. Maybe you're marketing yourself as I am the go-between. I am the master of these providers. We can make this happen. I'm going to stay on them. I'm going to be your customer service, customer support. I'm going to make it an easy, good experience for you. Work with me, and I'll make it happen. And then you've got to make it happen. And I mean, it's simple numbers, right? It's $1,000 contract. You're going to hire these people to do it for $500. You make $500 plus your time and other costs. So that's how it would probably work. And then you have to have different contracts, obviously, you as the agency with the service providers. If you are using people in the example I gave in Chile or India or whatever other place, or Albuquerque or Boston, whatever it is, and have contracts, and these may all be click through things that are commonly done, and those are probably fine, especially on the more general kinds of situations. But if there's any special circumstances, those should all be called out and specified, and how to deal with those special circumstances. What it comes down to is, can you give the client what they want and make them happy? So that then you can get good reviews and get more clients and customers, right?
No, I appreciate that, and I also love how everything comes back to the legalities of things, right? And the contracts that are in place, and that also, brings up another topic that's related to all this is another common thing that I see is people not understanding how to put contracts together. And they often use a lot of these turnkey services that they find online to, make a contract. Or worse yet, they look at a contract that exists for like, another entity. Like, I'm going to just use the terms of service contract from this website and copy and paste it, right? And so, again, a lot of people are skipping a lot of critical steps and trying to do things as cheap as possible without understanding the greater risk involved. So this is kind of a two-parter. One, what are the pros and cons of doing things in that manner, and what are the alternatives, and why is that a benefit to work with a lawyer instead? And what's the best process for someone to prepare before they sit down with a lawyer? Because I often see these people asking on like Reddit or other places, hey, give me a bunch of legal advice before I sit down with a lawyer, right? But they're asking a bunch of, not lawyers for this information. So they get a lot of
Right,
misinformation and bad
right.
information, which often leads to longer, more wasteful conversations because, often these people are
Yeah.
pushing back with the lawyers. Oh, I read this online. This person
Well,
told me.
they have to reteach or unteach what they learned wrongly. So you have to be, it's all this correction. So yeah, that's a good point. Um, in a general sense, if you have a Shopify account, for example, or some other retail account online, and there's a package that you're going to get, and it may come with some contracts, or you get other people's contracts who also sold stuff. If you're selling some sort of widget or gadget, electronic item, whatever it is, do people even know what a pet rock is anymore? But new pet rock, whatever a consumer item is, if you're selling stuff, the contracts are the contracts, and it should be somewhat similar. So it's somewhat safe if you're going to copy something like that or use a cookie cutter or whatever, whether you call it white label or brown label, whatever it is, some generic kind of thing that could apply to you, it probably would. But, in that silly example I just gave of a pet rock, consumer products, there's issues. Is the paint made out of something that is toxic or non-toxic? Do you have to have insurance? Is there a paragraph in your sales thing that says I'm not liable should you have allergies to the toxins in this thing that I don't know about? Is there a paragraph that would apply to that situation? Obviously you're not going to spell that out and scare the behoosies out of anybody trying to make a contract with you or buy something from you. But that's the sort of stuff you have to be careful of, because it may be a little bit different if you're selling, socks and T-shirts than if you are selling it's definitely 100% different if you're selling the other one. I think, like you just did, you just drank a drink, right? Let's say it's a new sports drink, or let's say it's a new nutritional supplement. There's a lot of people selling a lot of stuff, and there's a lot of potential for liability issues there. And your contract may not limit your damages or restrict the problems that you could face should there be a defective or harmful product in that supply chain. So go into it eyes open. It's a good basis. It's more like if you think about a tree with a big trunk and then limbs and smaller branches, and then there's leaves. You've got to deal with the leaves and the smaller branches, and the trunk and the trunk is probably fine, and the limbs are probably fine, but the branches and the leaves have to be created by you and your attorney, not you personally, because you don't know what you're doing. So
Appreciate that. David has a question. I have patents on what I believe solves the fundamental reasons debates are ineffective as positive change agents. When trying to attract CTOs or vendors to co create videos or other creative collaboration, it is hard to talk in generalities to attract interest in the first place. Thoughts? Thanks.
So you mean, I think David probably means, David, you can type it in or speak up, that you have ideas for patents, not you already have patents. And I mean, can't really think about things, since I haven't heard your voice and don't know exactly what you're saying. I'm going to answer a question that you may not have asked, which is, what do patents have to do with any of this? The whole point is, I've got a business idea, and this is how it's going to do something to solve a problem. Isn't that what every business is, right? Where you're trying to solve a problem or trying to make something in the world better. We're trying to provide a feature to somebody, and just go ahead and do that. It's about how you implement the thing and how you make it work and how you make your company successful, or how you achieve the business goals, or how you achieve the customer satisfaction, whatever your goals are. And that's very, very general. But patents typically protect functionality, functional physical things. Patents protect the way something operates, the way something is manufactured, and that's for what's called a utility patent. There's also design patents that protect the non-functional ornamental things, but we're not talking about those. And then if we get into the software area, software patents are currently difficult to get. It's kind of a wave. When something is new and exciting, it's patentable, and then when it becomes a standard tool, then it's not patentable. So this more recently, and you have yet to utter this my favorite two-letter word, right? Or AI, whatever you guys want to call it. It's just a bunch of software that does something. It's a black box. You put something in, something else comes out. AI is not a be all end all. I thought you were going to bring that up in the contract context. Should I ask ChatGPT or some similar sort of thing to write a contract between me and going back to the house stuff, the house painter or the guy mowing my lawn? It's like, yeah, maybe, but probably not for someone who's going to build $100,000 or $200 software package. Anyway, software is troublesome to patent. We can get certain software patents if they are an improvement on computer technology into and unto itself. But if you are using computer tools in their customary and expected way, then it's not patentable. So on the physical side of something, if you go to Home Depot or someplace and you buy a bunch of nuts, bolts, screws, metal, wood, whatever, you put together something and it's a better bowling ball mover. It allows you to get your bowling ball from upstairs to downstairs better or something. I don't know. Or a new track for wheelchairs or whatever it is. Then that contraption, if it's a physical arrangement of something that's new, then that's protected. That does apply generally to software. If it's a software that impacts something physical, if you have a controlling software that's moving data faster, it's processing images more efficiently, it's managing a warehouse possibly. Now that gets tricky because in the old days, if you're managing a warehouse, someone could sit there with a pad of paper and look at things and maybe even use binoculars or whatever. Have color-coded trucks, see them going around in the warehouse moving things. But now it's software that's tracking all that. If the software is replicating what a human could do, even if the human could do it with difficulty on a yellow pad and other physical things, then that software is not going to be patentable. Now, if the software came up with a new trick to make something a lot better, a lot faster, a lot stronger, then it's something that could potentially be patentable. And that example is something I worked on a few years back, which is how to manage equipment in a warehouse in an effective, efficient way. And that was a bear to get in the US. It took years and years of arguing with the patent office. A lot of times there has to be what in Europe was called the technical effect. We don't call it that in the US. In the US, they talk about the opposite, which is an abstract idea. It can't be an abstract idea. So that talking about it using European language, that there could be a technical effect, or there must be a technical effect to have the software be patentable. There's a good way of approaching things, unless it speaks to the pure essence of something to do with computing. And there are methods of moving data better, and those methods are patentable if they're spelled out in enough detail. Candidly, it's about how complicated something is. The more simple something is, it's not probably patentable on the software side. The more complicated it possibly is. I won't even say probably. I'll leave it as possibly. So let's see. Do you think I answered that okay, Gary?
I always do. Yeah, I mean, yeah, you went into a lot of examples and details, and it was very insightful. So yeah,
I'm going back to David's thing though. So one of the things that came up a couple of years ago was the phrase business method patents. If there's a method of doing business, it's not going to be patentable if it's implemented in software. If it is taking something that was done by a human and doing it in a more efficient, faster way, because that's what a computer allows you to do, that is a typical and expected result of the use of computers applied to something therefore it's not going to be patentable. Um, so that's a general way of looking at that. There's disfavored areas as well. If it's banking or finance, there's not a shot in heck that you're going to get software patented in those areas. So it gets, and if you do have patents that in those areas that were issued, so as I mentioned briefly for a second before, patents come in waves depending on the current cases that have been evaluated, the current, uh, let's say, the business climate. Sometimes it's the patent issuing office, sometimes it's the patent filtering office, and you don't get so many patents, or patent limiting office. And right now we're at a more limiting stage in the patent office with regard to software. A few years back, it was on the upswing, and many things could be patentable in the software space. But what happens is, after the patent issues, the patent will last another 10 or 18 or 15 years, whatever it happens to be. The total life of a patent is roughly 20 years from the time you file it to the time it ends. But your rights don't begin until you get an issued patent. So that's why the length of the active patent is different than the. Anyway, don't want to go down that rabbit hole too far. The point is, you may get a patent that issued in 2015, and it's only 10 years later, and you still have, let's say, 5 more years left on your patent. But if you went to assert that today, it would be invalidated in a second. So once you assert your patent, someone can then, the best defense is a good offense, could then take an action to invalidate your patent for not meeting the current criteria that's required for software patents. Just because it was patentable 10 years ago doesn't mean it's patentable today. So that's the concern with people having patents and waving them around. This is not about you, David. I don't know you or what you're talking about here, but it says I have patents. So let's see. Great. Okay, Gary, go for it.
Yeah. So Bev asked a question on the event page, left a comment. She can't attend right now, but love to get some insights and an idea of how she should approach this. Again, not legal advice, but how, best way to kind of
Well,
address this.
so what we're talking about is, I have a company. I'm reading what's
Yeah,
on the
yeah.
page, um, uh, and the company is making some sort of income, and they're using a name. I don't know why this person is asking about the states, or not, what state the people are in. So trademark rights, let's start from the beginning. Trademark protects a name, a slogan. It can also be a sound. It could be a color, and it could also be a graphic or a logo that a consumer associates with a certain product or service that's being provided by a company or person. Um, I'm wearing all generic stuff at the moment, so I can't even. Let's see. Do I have any products in front of me? Oh, here's
You
one that
got that. You
everybody.
got that Dodgers hat.
Oh, that doesn't. Yeah, I'm not going to say. So this is okay. Here we go. Purell, right? So that's a brand. I associate that brand with a particular product, which is this, and it's made by a particular company. I do not work with this company. I just happen to have this on my desk. It's not left over from COVID because it says it expires in 2026. What I'm looking for is, Purell is made by what company? Interesting, by Gojo Industries. I didn't know that, of Akron, Ohio. I thought it was a big player. I don't know who Gojo Industries is. That's so interesting. I assume Purell was made by some maybe it is a major company. I just don't know that company. So I associate Purell as a brand that's owned by this company, Gojo. Yeah, Gojo. Huh. Okay. So that's exciting. Nike's easier, right? Nike sneakers are owned by Nike. Apple Computer made by Apple. I mean, Apple computers, tablets, phones are made by Apple Computer. So that's trademarks. And by using a trademark, that company or person using that name and providing that service, in selling that product, putting their name on that product, gets common law rights. And common law rights, the example I like to use is like a little kid's plastic camera. Remember those little play sets you have with the plastic camera and the plastic screw, and then you bang them in. That's like common law rights. And then once you get a registered trademark, and also the common law rights are based on where you sell and to what extent you sell, and it's a very weak protection. The benefit of getting a federal trademark registration is that you get protection in the entire United States by filing in the United States. And if you want to protect in other jurisdictions in the world, it's done on a country by country basis. But for the special places like Europe and Africa, where you can get an African patent or a European patent that covers certain countries. Excuse me, I said patent. I meant to say trademark. Isn't that bad when the IP guy mixes up patents and trademarks? So anyway, trademarks is what we're talking about. And so the important thing is when you start offering a service or selling a product, you want to make sure that you can, imagine you're watching the Olympics and it's one of those running races and they shoot the gun and everybody runs at the same time. You don't want to be tripped up at the beginning by using somebody else's name. An example was actually a woman had a running club over here and she was using a name on a running club and she liked it and she bought all of her swag. She got her t-shirts, her mugs, her pens, whatever it was. And then she came to me to protect it after she invested a couple of $1,000s in swag. Turns out there's a company or a group in Denver that's using the same name and they had a federal registration and they came first, so they win. So she got to change her name. You don't want that to happen to you. You want to start out so that the seas are clear when you leave the port. You can go out, you can go sailing, you can go have a great boat ride. You don't want to be the next Titanic, which is a big disaster, right? But you also just don't want to run into the shore on the way out because you haven't looked yet. So you have to, it's just looking both ways before you cross the street. So you make sure that your name is not the same or similar to someone else's name in providing the same or similar product or service. And let's see, I'm going to see what this person, so essentially if you have a name and you're already in business, that may be okay, but you may be a small player so that a big player hasn't seen you yet. But once you get even bigger, and maybe you're only in 1 or 2 states, and maybe you're only in the West, it may turn out that name is very popular on the entire East Coast from Maine down to Florida and also over to Chicago and everywhere north and south of that, but not west. And if you're in the West, you may not know that, but that company on the eastern part of the country has a federal trademark registration that you haven't heard of yet. And just because you're selling here in maybe a little bit in California, a little bit in Nevada, maybe even up to Oregon. But if you came later and you haven't registered and you find out now that you're getting bigger, oh my gosh, you're going to have a problem. This happens on an international scope too. So someone came to me a few years back. They had a handful, like 6 or 7 bathing suit boutiques in Australia, and they had just signed up to go to the Miami swimsuit show. I guess that's what's big in that industry. Every year there's a Miami swimsuit show. I can't even say Miami swimsuit show. So you go there, but you sign up in advance, and someone then notified her saying, "Hey, you're going to have a problem because." Actually, no, it wasn't that. It was I'm the one who told her she had the problem. She came to me and said, "Hey, I want to protect this name. I'm expanding out of Australia. I want to protect the rest of the world." It turns out the rest of the world was already covered. Someone else had already been using that name in the U.S. and in Europe and South America. They didn't bother with Australia for whatever reason. They also didn't bother with Asia, but they were in Europe and the U.S. and South America. And so she could continue using her name in Australia, but for when she wanted to go overseas, she would have to change her name. So that's the sort of thing you want to look at. The person who asked about the trademarks is make sure that you have a clear path going forward. So make sure you do your own trademark search, then hire an attorney that you can see face to face. Do not hire someone blindly online. There's a lot of scam companies out there as well. You're talking about agencies and things like that. There's just whack-a-mole fake companies out there. If you type in something like search trademarks, some of them may be real and some of them may not be. So you really want to use, I would recommend a local attorney in your community. You're also going to need a business attorney as well, sooner or later, to form the entity to deal with your income and to manage the ownership of the company. So that person can work hand in hand with your trademark attorney or your business. So oftentimes I will send people to a business attorney before they work with me to form their company, to form their corporation, and then we'll come back and we'll do the real work after they form their business entity. So it's kind of a longer answer, but I think that was necessary.
Yeah, no, the longer answers are great because there's a lot of context and foundational concepts that make way for all these things to be built upon, and it's really helpful for everyone to understand that. Yeah. Okay. So Cassio asks, I was hoping to have a discussion on the legality of web scraping and database law, the applicable causes of actions, definitions, defenses, and the most interesting recent case law, and any thoughts on future developments in this area of law. A discussion on bright data, high Q, and other cases would be helpful if time allows.
Okay, so this has been one of those things that's been evolving for many years now. And it goes back to almost what we were talking about, the same issue of the agency, making sure that you use only licensed IP when you go ahead and put things on your webpage, in your app, or use it as content in the materials you're providing to people. It has to do with how you as an entrepreneur access that information and acquire the information. Was it acquired legally? And that's what Cassio's question is, which is, can I go have a bot that scrapes things from other websites, and then it becomes my property since I scraped it because I could, and if I can, therefore it is. Um, the analogy in the real world is quite simple. So okay, let's just back it up 1 second. Scraping. I have a bot. I empower it. It goes. Let's just make an algorithm. It goes numerically, whatever it is, from domain name to domain name based on numbers. And it's hey, can I look at this domain name? Oh, I can. Oh, are there images? Oh, there's a JPEG. I'm going to pull all the JPEGs from that. It's like those, and then it pulls the JPEGs. It goes on to the next domain name, and then it crawls for the folders on each of those domains. And then all of a sudden, you have all these JPEGs. And that's what scraping is. It could be scraping. I was giving the example here with JPEGs and images, but it could also be text documents or plain text. Since plain text, if you're giving it away, it must be owned by the person acquiring it, right? Because it's plain text. Well, let's give it a real world example. I'm walking up and down my street. Do I get to walk onto my neighbor's lawn and pull out whatever plants I want from their yard because I can see them and I can do that? And maybe it's easy for me to pull some of those plants out, or maybe they have yard gnomes, and that I like those yard gnomes. I want to pull all the yard gnomes from the neighborhood because I can walk down my street. That's public space. And then I walk into the private space and I pull the yard gnome and I walk back out and no one's stopping me and there's no fence up, right? So that's public domain, that's public access, right? The answer is no. Obviously, we all think about that. Those are people's homes, those are people's private property. And the real question here is whether going into someone's domain and the files and folders that make up the website and other offerings on a domain name, if that stuff, again, text files, JPEGs, whatever it is, it could be the code itself, which we haven't talked about, all that stuff, is that stuff now mine just because I can pull it down? And the answer is no, it's not yours just because you can pull it down. So I'm talking very generally. I'm not up on the cases that Cassio is asking about. I haven't been reading the details of these things recently. And I'm generally familiar with the concept. So what I'm saying is somewhat right and somewhat not right, but it's generally right. So that's the caveat here. But I think by painting that picture of real property and yard gnomes, I think actually makes you understand, hopefully, everyone listening, that this is an issue that matters. This is a big problem going back to the AI stuff that's always in the news, is how are these AI systems trained and on what data were they trained? And was the data legally used? There's a couple of lawsuits about that. I'm not sure if they're shaken out yet, if they're still going. One of the biggest ones was New York Times. I know going after one of the AI companies. And then there's another thing that Cassie mentioned. So we mentioned two things: web scraping and database law. So a lot of this has to do with copyright. So when somebody creates something, that something is owned by the creator. That creation could be a photograph that I took with my camera. I, as the photographer, own that image. If it's a yellow pad and I wrote down something in text, that text is owned by me. I created that. If I doodle on that pad or create a wonderful work of art on that pad with a pen or pencil, or I take a canvas and I paint something on it, that is owned by me as the creator. And then by analogy, software is also protected by copyright. Whether I write it by hand on a yellow pad or whether I type it into my computer and save it as whatever file format I want to save it as. That text that creates things on my computer that functions as software code, that stuff is protected by copyright. So, and then there's data. Data would be if I can go onto the website and I can look at the login history and I can see who has ever been on this 805startups.com website. Can I take that list and then sell that list for marketing purposes to another company saying, look, I know some tech entrepreneurs that may want to use your services. And you sell that to multiple people all across the interweb tubes. Is that okay? And if it feels okay to you, then maybe it is. But the law it doesn't necessarily catch up with things right away. Because a lot of the stuff that was considered okay at the beginning ended up not being okay. This, in my mind, this kind of started when Google was scanning all sorts of books from all sorts of libraries years ago, and some of you may remember that. But then that was stopped because it was all copyright infringement. It doesn't mean that Google didn't keep all that and didn't use it to then train their AI. That's another question for a different day. But having access to other people's creations doesn't mean you own those creations. It doesn't mean you have a right to use those creations without licensing or proper legal constructs that control your ability to do that. So I'm not sure exactly what Cassie means by database law specifically here. I'm thinking more of the general things that would be available in logs, as well as the content that is used on web pages, and then the software code itself. So.
Yeah, Cassie, if you have any follow-ups or if you want to use your camera and mic, again, camera's optional, but if you want to come up on stage to expand and have more of a back and forth, feel free to let me know and I can bring you up.
Cassia's on the block. You can just buy me a coffee next week, Cassia.
That too. You always do that. In the meantime, going back to what you said in regards to finding a local lawyer, attorney, what are the best ways to identify one that is a good fit for you and reach out to them?
That's a really good question, because I've been in this community now for more than 20 years, so I know lots of people who do lots of different things. And I know that I don't know why I'm focusing on my yard today, but if I know I need someone to tend to my yard and mow the lawn or paint my house, I know 3, 4, 6 realtors, and I would ask them because they are often helping houses get in shape for sales. So they know the painters, so I know someone to ask about that. In that same vein, if I'm pretty confident that those same realtors, this is by way of example, would know a business lawyer, because some of these real estate deals they're working on are among companies or between companies or to or from a company, or not just a person buying the house, or if the person may have an LLC. So they may know business people as well. So that's how one way of finding a business attorney is, if you think about who your trusted people are in your circles and ask them who they have used and who they know. That's one way. In our local community, luckily, we are surrounded by some universities that have good entrepreneurship programs, and there's mentors and volunteers involved with those programs who they themselves could help you, or more importantly, they can refer you to people who they've used in the past. So this is a local group, so everyone here already knows about Hub 101. So you go to Hub 101 and you ask any people there who they are using, whether it's someone working for Kalu or if it's one of the current entrepreneurs that are actually renting space today over at Hub 101. They can tell you who they're using or who they've seen in town. Or you can just go to the 805 Startups website and see who is committed to the community. I noticed that coming up here, we've got a business attorney in the next week or two here today for IP. I know there's been some other IP attorneys as well. So I think anybody that's committed to the community is a great resource to use. And 805 Startups has been great at making all of us available to you, the people who are involved with the technology entrepreneurship things in the neighborhood.
Appreciate that. And yeah, the universities and accelerators and just other community-based organizations, even chamber of commerces, right? Like Mark said, look for the firms, the lawyers that are contributing actively in the community. Those are the best ones to start with. And like Mark already said, Mark makes referrals to other lawyers, right? So if you're not a good fit for one, they know others that are in the community. And if they're a good person, they'll be happy to make that referral because they know that they're a part of the community as a whole. And there's no reason to, be so petty as to not make referrals when they know
Oh, sure.
someone's a better fit.
Yeah, so reading between the lines. So if someone came to me and luckily I work with all sizes of clients currently, but I may get too busy next month and I may want to say, oh my gosh, this sounds cool, but you're a little bit, I'm too busy, or some of this is not a fit for some reason, but I know these other two IP attorneys and I would refer off to one of those two guys or both of those two guys and let that person go to town that way. This happens more so in two other reasons. One is it's just a different skill set. So I don't work in the biotech space. If you came here with some sort of biotech whiz bang gadget, I'm not going to be able to help you. I'm saying gadget. If it's a gadget, we probably could help you. But if it's something purely biotech and dealing with biology or dealing with chemical related things, I would send you off to a separate specialist. So it's like you don't go to a podiatrist when you have a major toothache and need an oral surgeon, and you don't go to the oral surgeon when your foot hurts, right? It's that same sort of thing. So I'm going to send you to the right person to get it done. The other is conflict. Sometimes you may come to me with something in, I don't know, well, let's say it's the, I don't know, compressed video space. And I have a client who worked on that thing in the last couple of years and I'm still working with them. So I have to refer you out because I'm conflicted out. I can't, according to the rules of ethics, represent two competing companies in this space. And that does happen occasionally. And we cross refer in town here in the bigger region on a regular basis when those things happen. So yeah, happy to do that.
Love it. I appreciate that too. Okay, so G. Smith asks, I understand that games are not patentable, but rules of play, game format, game structure, etc. may be patentable. Can you elaborate on this situation? Thank you.
Oof, so many different games, so many different things. Um, so yes, and no to all that. Not in any order. It all depends, is what it comes down to. Um, So let's start with you have a new board game and you create, let's say it's all, I don't know, hexagonal squares. Does not make sense. Hexagonal areas on a board that form a big square, and you create your own set of characters, whether it's 6 or 16 characters. Who really cares for this example? But you create that, and then you have a set of rules about what happens. And whether you have a six-sided die or two dice or you have something else. So this is more of a how do you protect your IP for any sort of new product, right? In this situation, we look at copyright. The physical ornamental, excuse me, the board itself is physical, and the ornamentation on there, the decorations, I just said it's a board with a bunch of hexagons. That itself, that's probably not protected. So copyright does not protect functional things. So arguably that's functional. But if you have different graphics in each of those different hexagons, each of those separate graphical items taken alone or the combination of graphical items together could be considered an artwork. In that situation, then it is protectable. Each of the pieces are little statues, and each of the statues is then protectable as copyright as well. It's a creative work. And as you mentioned, the rules themselves are text. Anything in text is a creation because it can be created and do different things. So that is protected by copyright. The names of the characters of each of these little figurines that are in the hexagons on there on the board, each of those little guys could have a name, and if it's a unique name, those could be protected with trademarks possibly. But more importantly, the game itself, the name of the game, is protected with a trademark. The logo for the game and/or the slogan that's associated with the game is protectable with a trademark. And the logo used for the name of the game could be protectable with a copyright as well. And if you have a software version of this game, this is funny why I'm thinking of board games, by the way, because you wrote rules of play, game format, game structure. Okay, it's interesting. I decided to focus on board games. I'll tell you why I just got distracted in a second. Because I was going to go with, then you have the software version of the game. Like everyone has played Monopoly growing up, there's a software version of Monopoly. There's a software app named Jeopardy that's based on the real Jeopardy game, which is more of a TV game than a board game. But still, software is going to be protectable for the same reason that any other software is protectable. Um, and if there are unique technological tricks that have to be implemented either for safety, security, lockdowns, access, then there could be some software patents in these things. So let's say you want to create a unique game, and I said hexagonal. So what's that? 6 sides. So let's say this game has to always have 6 people, and you always have to have two teams. Excuse me. Yeah, you can have 2 teams of 3 and 3 teams of 2, and they have to overlap or something. And there could be a way of coding these things that allows for sharing of certain data, but not sharing of other data. So there could be computer science tricks in there that could be protectable. When you say games, though, most of the people that I talk to, games are all software, right? What do you have on your PlayStation or whatever other box it is that you're using? So there's that. And let's see. And then paper cards and video game format. So I'm not sure what let's see, G Smith. Is it Gary's? There's too many Garys today. Gary, how many Garys do we have today?
I have no idea, but
So
I'm gonna say this is a Greg.
okay, it's Greg. There we go. Well, I used to know a Greg Smith too. So, but yeah, so games are certain. So the other kinds of games that, which is I didn't talk about, were card games, which you did just mention. Card games are tricky. Some card games are protectable and some are. We've done some work in that space, and I'm not up on the resolution of that. I know we've had issues with getting card games protected or protectable. And another piece of that puzzle is if it's a unique card game, the graphics and images on there are protectable with copyright, and the name of the game itself is protectable with trademark. And it's Mr. Smith wrote that it is a book format game, an audio book, not associated with a physical board. Just like I have not really done my diligence today mentioning music or audio, but music and audio are protected by copyright when they are fixed in a tangible media. And in addition to that, a certain sound, if it's associated with a product, or in this case, a game, could be protected with a trademark registration. So if you use the Homer Simpson Doe or the You've Got Mail, or in the old days, they used to have that THX sound effect thing at the beginning of movies, different things that you associated, that you as a consumer associate with a certain product or offering are protectable as trademarks. So there's ways to build in protection that you know that if you're going to have a certain sound at the beginning of every audio segment in that game, either generally or for specific characters, for whatever, each of those separate things, whether it's 1, 2, or 15, whatever the number is, could be possibly protected as a trademark if consumers associate that sound with that particular game. So that's maybe a neat trick you're learning today, that most people don't think about sounds as protectable as trademarks, but only as copyrights. And I'm not sure what Mr. Smith is getting at about the book format game, audio book, not associated with physical board playing service. I need more to understand that, so I apologize. I can't really address that. Should we move on to the next one, Gary?
Yeah, we're coming up on time.
Well, I started late, so we get like 7 minutes bonus.
All right, we got another
That's
six. It's
typical.
another
That's
six
typical.
bonus. All right, so on YouTube, JB asked, as an owner of NFTs, how could a creator owning the IP take advantage of me? And then I added some additional commentary. What risks do people need to be aware of when buying and owning NFTs? Related, recently, many NFTs have resulted in dead links due to servers not being maintained that link the NFT to the hosted artwork. So there's a couple different things, but yeah, I'd love to hear your insights on NFTs and what's going on.
That's so interesting. I have not heard boo about NFTs in the last, maybe because I've got my head down in other places, but NFTs really rode the wave for a while, and it's been completely supplanted in the public consciousness now with AI. We haven't the blockchain. Oh my gosh, what the heck is blockchain? That was so 2022. Um, so interesting how pop culture impacts perception of technology. But that's a different discussion for a different day. So today we're looking about the last question, and we're going to deal with our second or third last question, whatever. NFTs. It's problematic. I'm never a fan personally. Even though I'm a tech attorney, I am the most skeptical person about certain kinds of tech, um, especially when so much of it is just manipulating pop culture images and not necessarily creative, or buying an NFT and doing what with it for what purpose. It doesn't resonate to me personally, but that's more my bias, and I admit that. Um, and you're asking here is a very good question, which is how could a creator owning the IP take advantage of me as the NFT owner? Um, Quite simply, it's like when looking at the wall. Nothing shows in my screen right now, but there's an artwork on the wall over there. That one says artist proof 38 out of 45, right? So how did that artist take advantage of me? It's an artist proof 38 of 45. That's great. How many originals were there? Not originals of the that weren't artist proofs was I don't know how many. And then he may have at least it says out of 45. But there may be a second version of that. So it's a more matter of if you, as a consumer, are buying an NFT, the creator could just sell multiple versions of the same thing. And how are you going to know that? Well, NFT is supposed to be non-fungible. It's supposed to be, uniquely identifiable. So that doesn't happen except for when I'm not creating one that's uniquely identifiable. I'm creating 1,000. I'm creating 10,000. And when you bought it, you thought you were the only one. Which increases the value of it because it's now a scarce item. It's a supply demand issue. And if that creator is going to be selling other NFTs with the same artwork underlying it or the same whatever happens to be underlying the NFT, then that's going to reduce your value. And then you're talking about servers and just maintenance and all that. That's any sort of relationship about does the company you're buying from, the person you're buying from, business, do they support their product? So if I buy a car and it has a 10-year warranty, I don't really care because that car company, let's say it's Rivian or something or Lucid, that could go out of business in a couple of years. Those are tenuous companies, and even if the battery has a 10-year warranty, I may not be able to get it serviced in 5 years because that company's gone. So that's the sort of example you're talking about. So a lot of the things, what you hear me doing though, is often and almost always analogizing between a more well-established or tested type of thing in our world that we're all used to compared to some new technology. Because to my mind, the old informs the new, and the new questions are not really new questions. They're the same old questions asked about a new thing. And that's how I look at this question about the NFTs. So hopefully that helped a little bit.
Yeah. JB appreciates the answer and insight. Yeah, and I mean you touch on a lot of stuff too. Like it's a very new technology, NFTs, and like Alon, co-founder, he's big into the blockchain world and was sharing with me and what NFTs were kind of you know marketed as is something that's so far removed from where they are today. It's like, here's the vision, but it's still in the earliest stages, and there's so many different issues with them and, problems. And as we've seen, like as I touched on, a couple of these companies that have put them out, that are hosting them and, running some of these things, they're now useless because there's no artwork attached to them anymore. And that's the point of it, right? At least one of the main points. And so, yeah, I think like you touched on with the car analogy is beautifully eloquent because it's exactly that. Like you got to be aware of the larger risk, not only with the technology, but with the individual that you're engaged with. And ultimately, the point of the NFT, ideally, is like to make that artwork that you're buying something that you invest in to sell off later. But if there's not demand for it, or if it's not properly maintained, so it deteriorates and you can't, resell it, there's no point to it, right? So, yeah.
All right. Do we have any other questions pending? I don't see any in the chat. Gary, do you have any other last questions? I lost your audio.
Oh, goodness gracious, I did that. All right. How long was it muted?
5 seconds.
Okay. Not good. Okay, good. Yeah, you touched on all like the real good basic ones with best practices that I like to, hone in on. Um, yeah, if you have, you know, I guess it'd be good to hear one common mistake that you want to call attention to and a way to address that and avoid it. Real simple.
Yeah, we actually talked about that. Make sure what you are two things, I guess. Make sure what you want to use is yours to use, right? Do you have rights to this thing? Again, going back to the examples I gave earlier, photos, software, whatever it is, just because it says it's free, make sure it's available. Or just because somebody said it's in the public domain, make sure it is, verify that so you don't get bit later. And the other thing is when you come up with something, see if you can protect it. That's one side of that coin. The other side is make sure you're not going to be sued for using someone else's something. It could be too close. Even if something you created, it could be too close to somebody else's thing, whatever it is. It could be a logo, it could be a name, it could be a technology. So you have to make sure the waters are clear and do different searching. And so those are the two things. So again, one is make sure you have rights to what you are going to be using. And the other is make sure you do searching to make sure what you are going to be using is not going to, if you're creating it yourself, is not going to infringe someone else's pre-existing rights.
Appreciate it. Love it. It's great. Clip that later and share with people. All right.
Okay.
So if there's no further questions coming in, Mark, I want to say thank you so much. This is wonderful. Yeah, love to have you back. We got to get some coffee too. And
Yeah.
yeah.
I apologize for being late. Sorry about the technical issues. That was funny.
No. This platform too, it's new, and there's a couple little bugs. So it's what it is. David, Cassio, G. Smith. My goodness, I've got to jump over different platforms. Yeah, JB, thank you for contributing and asking wonderful questions, and hopefully that was helpful. I posted Mark's LinkedIn in the chat. It's also on the event pages, so if you want to reach out to Mark, follow up. If you have more, you want to ask him for help. He's got a wonderful firm. Yeah, don't be shy. And if he can't help, he'll refer you to someone that can. Yeah, so with that, thank you so much. All right, cool. All right, Mark, I'll catch you later. Thank you, everyone. Yeah, have a wonderful